Well, hello, Mr. Tompkins, and thank you for taking the time out to meet with me and discuss your case. I hope your recovery is proceeding nicely. Unfortunately, I have some bad news on the matter that I wish I didn't have to deliver. Now, as you know, when we commenced action, we made the strategic decision to file the case in federal court in New York. That was an option that was available to us because of something that's called diversity jurisdiction. You being a citizen of the state of Pennsylvania and the Erie Railroad effectively being a citizen of the state of New York, combined with the fact that the amount at issue, your injury, crossed a certain dollar threshold, enabled us to file in federal court rather than in a state court. Now, under a court decision that has been in effect for nearly 100 years, filing in federal court under these circumstances subject you to what was called federal common law. In that circumstance, judges were allowed to apply either established rules or what they determined the legal rules should be governing the matter. So under that judge-made law, you would have been considered a de facto user of the railroad, meaning that Erie owed you an obligation to avoid negligently injuring you. Now, as you'll recall, pursuant to our previous discussions, had we filed in state court in Pennsylvania, Pennsylvania law would have applied. And under that set of law, you would have been deemed a trespasser by walking alongside the railroad, meaning that Erie's obligation to you was dissimilar, insofar as that in that circumstance they would only have to avoid willful or active behavior resulting in your harm. Now, unfortunately, in the U.S. Supreme Court case that was just handed down in your matter, the court has reversed that longstanding decision. And in so doing, they found that while you could still file in federal court, applying the procedural rules, so the diversity of your and Erie's citizenship and the amount at issue, so you could still file there. However, they've reversed themselves and deemed that since the injury that befell you occurred in Pennsylvania, the substantive law of Pennsylvania should apply to your claim against the railroad. Now, the court views this reversal as preventing a sort of perverse outcome in which parties could essentially shop for venues and parties outside of a state having greater protection from the state than the state's own citizens. Unfortunately, the upshot as it relates to you is negative. The U.S. Supreme Court has ordered that this be sent back to the federal court where it was most recently tried, and that the federal court apply Pennsylvania law, in effect, applying the rules that would make you a trespasser on the railroad's property, and therefore applying a more adverse body of law to your situation. So as it is, to be completely frank, there's very little chance that you will win and be compensated for your injuries. And again, I'm very sorry you're experiencing this and appreciating you taking the time out to talk with me.